the public domain is invisible and undervalued and under attack. But maybe part of the problem is that we haven't tried to map the public domain. We haven't tried to sort of create a kind of rich intellectual environment and sort of what are its component parts and which parts of it are really important and more important than others and so forth. And it seemed to me that that actually might be useful, not only because then it's sort of a way of valuing something to map it and to sort of say what its contents are, but it also may give us something of a handle, some tool for understanding what kinds of threats certain kinds of initiatives pose. And what I'm going to suggest to you is that often when we talk about attacks on the public domain, what we end up sort of saying is, oh, it's going to destroy the public domain. And actually what it's going to do is kind of have a bad effect on some portion of the public domain. So if we have a kind of map of the terrain, maybe it will help us to sort of to see what kinds of implications any particular initiative might have. And because I'm not clever enough with PowerPoint yet to do this, I did it by hand. So this is my slide. Now, the thing is, it really only goes like this, but as you know, we all like to read. So obviously the center part of this this diagram was an intent to sort of say here are at least some of the component parts of the public domain, and sort of they're from sort of more abstract to kind of less abstract things. And around it are such things as the intellectual property laws, which have important functions. And I have to sort of slide this up now so that you can see that trademark and copyright are here. As was explained in some of the earlier panels, some people will take things like open source, things that are widely available without restrictions, such as the material that's on the World Wide Web, and fair uses as part of the public domain. For my purposes, I'm suggesting that they're contiguous territories, and so let's say there's easier transport across those borders than across some of the other borders. But I think actually another thing to sort of understand about the public domain is that lots of things flow into it. Whether there are plant variety protection rights that expire over time, patents obviously expire. Trade secrets are leaky because sometimes either people reverse engineer it or they blab their secret to other people. And of course, patents expire and copyrights expire. And so there's a kind of flow, right? There's a kind of flow. It's like a bunch of rivers or streams essentially feeding the public domain regularly, and it seems to me that that's worth pointing out, and that's one of the reasons that I like this kind of map concept. Is kind of imagine lots of rivers. I like rivers. So that was sort of the basic idea. Now, obviously, one of the things that this shows is that the public domain is growing every day, and it grows really a lot. Sometimes faster, and sometimes slower, but it really grows a lot. Occasionally, and this is what a lot of us have spent time on, what you find is sort of one of the intellectual property laws coming in and sort of having an incursion and bringing something that was in the public domain out, and business method patents is a nice example of something that really for hundreds of years was thought to not be patentable. Now, under at least the Federal Circuit's analysis, they are. Interestingly, this was rejected in Europe, and I think that's quite a significant thing. Anyway, so things both flow into it and sometimes get pulled out of it, and I think that's interesting. Now, my task actually was not to describe assaults generally. Sorry. Whew. My task was not to describe the public domain generally or assaults on the public domain generally. Rather, it was to focus on digital information. And so it seemed to me that one of the things that I should do is try to sort of say, where are digital things found kind of in this public domain space? Obviously, there's lots of them at the kind of fact, data, information, law, regulation, judicial opinions, all kinds of kind of government information is public domain. Lots of it also can be found in works that are qualify for copyright or qualify for patent, but don't, for one reason or another, get are not, either the rights have expired or the people decided not to claim those rights. And there's, of course, lots of things that don't qualify for intellectual property protection too, that are digital, and then some of the stuff in the bottom too. Obviously, there's a lot going on in terms of digital in this kind of contiguous space. And actually, one of the things that the paper tries to talk about is the fact that digitalization and digital networks have vastly increased the sort of the information that's widely available. And Jessica Littman's talk this morning chronicled and gave more examples of that. But this space is a lot bigger now because of the internet. And I think that is a significant fact. I agree with Jessica on that. Also, open source is something which is a digitalization kind of thing that's contiguous to the public domain. And fair uses are also, at least until technical locks, are really quite possible on the internet too. So that's kind of then where the digital stuff ends up. So then the question was, well, what do various of the legal and policy initiatives that have been considered over the last couple of years, how does all that affect the public domain? And so here is my brief effort to sort of think about the Copyright Term Extension Act as a kind of dam that was created that stops the flow of those rivers into the public domain. And I think that is sort of a helpful way of thinking about it, because there was that flow that was happening every year, and that flow has now been stopped up. Now, this actually is an important development. I think it affects non-digital information more than it affects digital information, because most of the copyrighted works that were about to expire were not in digital form, and so the impact on the digital public domain is the impediment to Eric Eldred and people like him in putting materials that would have been in the public domain there. But in some sense, I think the Copyright Term Extension Act really does affect more than the digital domain, and so I'm not gonna talk too much about it, because I think its implications are more for other kinds of information. And then I sort of consider a couple of initiatives that are really aimed at digital information, and one of them that I talk about is the anti-cyber squatting legislation. Those of you who are not followers of this space still may know that there has been a new law created sort of forbidding the registration of certain names as domain names in bad faith, when a trademark owner might think that the trademark owner is entitled to that. And even if there is no possibility of confusion about this source of information vis-a-vis the trademark owner, the anti-cyber squatting law now allows them to sort of do that. And so that's an incursion on the public domain in ways that trademark law didn't allow. But I'm going to suggest that as incursions go, I don't like it, but as incursions go, it's a small incursion rather than a big one. Now, you got to watch small ones, because they can kind of creep up, and once they get started, they can grow and they become models for other things. But it does seem to me, again, the paper suggests that this one is a relatively modest one by comparison with some of the others. Two of the more significant incursions on the public domain, I think, come from the database legislation that Jerry and I wrote about, and that Yochai has written about, and many of us here have been concerned about. And part of what's of concern about the database legislation is that, in fact, it reaches down into lots of the parts of the public domain, not just one sector, right? If you read the law and you read some of the information about it, it makes it sound like, oh, we're only going to control this. Of course, only if you control this do you control like all the things above it, right? So if you sort of think about ideas, concepts, theories, scientific principles, and the like, okay, if you control that flow of the information, that information is core to the sort of the ability to do those more abstract innovations. And so it does seem to me that even though the database legislation is not directed at scientific principles and concepts and theories, in fact, it has an indirect effect. It's like setting up a sort of siege camp, right? If you kind of you have this invading army and they like occupy the sort of the space above the mountains, then they can control what goes in and out, and that's something to be concerned about. Now, I don't put laws, regulations, judicial opinions, and other government information directly in that, because at least some of the database laws have been excluding government information, partly because many of the firms want to privatize what they get from the government, so they don't want the government to be able to own it. In some countries, European Union, for example, laws, so there would be another arrow going down to laws, regulations, and the like. But I think it's important to sort of understand that this, in fact, reaches down pretty widely in the public domain. And in fact, I think affects almost all component parts of the public domain, and that is really a reason to be very careful about it. Now, there is actually a narrower bill, which some of us have also written about, which is really a kind of misappropriation bill. Sort of, you can't duplicate somebody else's database and sell it in direct competition to other people, okay? I'm going to suggest that although that's an incursion on the public domain too, it's a much more narrowly targeted incursion, and at least you can make a somewhat plausible argument that it was not something that would, in fact, have deleterious consequences. And so it seems to me that it's worth noting that depending on how the database legislation is framed, it can have more or less negative effects on the public domain. Then there is UCITA. And the more I thought about the Uniform Computer Information Transactions Act, the more different parts of it that I thought were incurred upon. In fact, I should find my pen and draw an arrow up here into open source too, because although the open source movement relies on licensing and the ability to kind of have a standard contract that essentially goes with the digital information. Open source developers rely very heavily on the right to reverse engineer other people's stuff, and you can't do open source if you can't do reverse engineering. And to the extent that UCITA might be successful in stopping reverse engineering through enforceability of anti-reverse engineering clauses of shrink-wrap licenses or click-through licenses, it seems to me that would have a potential negative effect up here too. Clearly, the UCITA doesn't just apply to public domain information. It applies to trade secrets. It applies to copyright. I haven't heard it talked about in terms of trademarks and patents, but although at an earlier point those kinds of licenses were excluded from UCITA, now to the extent that any trademark or patent involves computer information, it also is within the scope of UCITA. And so in some sense, UCITA could, depending on certain trajectories, essentially displace all of the intellectual property laws, or at least leave them out there as mere background rules that UCITA contracts go around. And again, it seems to me that that is worth paying attention to. Now, that isn't to say that every time there is a contract that would change a default rule of an intellectual property system, that necessarily is an objectionable thing. But it does seem to me that many of us have thought and worried about the extent to which UCITA, by presumptively validating all clauses in these mass market licenses, has the potential to override, right, whatever the intellectual property laws have as sort of balancing principles, and then that's really the kind of the aspect of the incursion on the public domain that really is the most worrisome. So this is actually a place where it is not necessarily the case in the body of the statute itself that the digital public domain is directly negatively affected. I think the direct negative effect is much clearer from broad-based database rights. But what UCITA is a kind of toolkit to create your own intellectual property law, right? And to sort of to draw upon the parts of the intellectual property law you like and basically contract around all the parts that you don't like. And so you get all the rights and none of the responsibilities, and isn't that a great thing? Well, at least some people think so, and some of the rest of us don't. Anyway, so my thought then was that that if we take a look at these maps and sort of see how many different parts of the terrain are really being affected by this law, we have actually a better concept of what it is that is the big drain. And I got one final map, and that's my DMCA map. Now, the Digital Millennium Copyright Act is a law that I really hate. And I have written a lot about it, and I'm afraid I am not finished yet. So I got some more arrows to throw at that thing. But I have to say, in all candor, that although I am among those who have said that the DMCA has negative implications for the public domain, by comparison with UCITA, it isn't even in the same league. Because right now, most of the things that the DMCA would protect are actually full in copyright already. And it may have more effect on fair use, and it may have some effect on public domain information. But I haven't seen a lot of public domain movies. Maybe there aren't any. No, there are few. But it's just not been used very much so far, and so what we have to say is that's a potentiality of the thing to have more of a negative impact on the public domain. But I think, in truth, you have to say that it's not there yet. And so I think that also, I think with the DMCA anti-circumvention rules, what you have, again, is something that has an indirect effect, right? In some sense, it's like UCITA, in that it provides a kind of toolkit that people can use in certain ways. You can actually build these systems to allow fair use. It's just that most of the people who do it don't. And so it's indirectly a challenge against fair use and against the public domain, rather than sort of a direct incursion. But again, it reinforces the kind of private action to do something to override the intellectual property rights, and more effectively, really, than with contracts, because you can always breach a contract, and I will sort of pull Jane Ginsburg out of the literature for a minute and say, right of fair breach. I love that concept, right? To the extent that contract law took over from copyright, I think it's almost inevitable that there would be a kind of concept of fair breach that would arise, just because it performs the same function as fair use has provided in copyright. So the paper also celebrates many enhancements of the public domain that digitalization and digital networks have made possible. I give a number of examples in the paper. I think the Thomas database of information about legislation is an incredibly useful resource. The Legal Information Institute at Cornell and its Supreme Court database, I think, is incredibly useful information, and it really is because of the low costs that are associated with digital information that you can provide those kind of resources. And I also celebrate the efforts of many of us here today to try to help build a kind of legal infrastructure to support the technical infrastructure and the initiatives to promote commons. And so I'm here both to talk about assaults, but also to celebrate new enrichments that the digital environment has provided for the public domain. Thank you.
So we're going to have 10 minutes of questions, though I know you could ask many more for Pam, and then we'll turn to Jerry. So, stick your hands up. You should be aware, by the way, that the little black things on your desks are not aborted hockey pucks or raisins that have been ground in there, but microphones. There are two dangers to this. One is that you will bang your fist on them and blow the speakers out. The second is you will whisper something and it will be picked up and broadcast to the world. I make you aware of both of these in the spirit of full disclosure. So, Pam, do you want to call on people?
Evan?
Yeah, Pam, I don't mean to be cross, but I do want to say a couple of things about what happens when free software is an ancillary to the public domain. That membrane of yours that things cross back and forth easily also allows for a move, which I hear you make a couple of times, in which that's not an assault on the public domain, which is an assault on free software, because it's on the other side of the membrane. The way you treated DMCA just now didn't say there's a whole lot of stuff you can't do because 1201 prevents you from releasing technical information, ideas, concepts, and hypotheses in the normal language in which you would do that, which is executable computer code. So we've got a young Russian in a jail in the US and a young Norwegian in a police station in Norway for attempting to contribute to the public domain, or whatever we want to call that area of freedom, and being blocked by DMCA in a very direct fashion. Similarly, it seems to me that it would be good to make just a little technical statement about UCITA there, because when you put the map up, I thought that's right. There is no arrow moving towards free software, and it's true that there shouldn't be. The reverse engineering problem is a terribly serious one, and we are fighting UCITA on that basis. But I do need to point out to people that our argument is, with respect to GPL in particular, that UCITA has not the slightest application because it is not a contract. And it is important to me to point that out because it is important to me to suggest that it is not a membrane as you have sketched it there. There's the public domain over here, and then there is open source free software, which is in a sense on the other side of a contractual membrane. That's not how I conceptually think about it, and I don't think that's how our arrangements work. Our arrangements work, from my point of view, by saying we permit you to do things copyright law would otherwise prevent you from doing. We make a public domain within the sphere of the non-expired copyright on the software that somebody owns. And we do that with only the condition that if you mean to copy and distribute modified or unmodified versions, you must do so under a particular set of permissions. And I don't want to have had this conversation in public and not said that, because it's going to be terribly important down the line. We make no contract with anybody. That statute has no application to us at all. We exist solely within a regime of copyright for which UCITA has nothing to say, and we're not going to ignore the fact that the commissioners for uniform state laws say in their comments, if you have no contract terms, we add no contract terms. I see no contract terms in the way that free software does business, and I see nothing in UCITA that claims that it has any power to add any.
Well, thank you for those very helpful comments. I do think that I do think that it's useful to distinguish between open source and talk about it as a contiguous territory to the public domain for precisely the reasons that you're talking about, because of the restrictions on appropriability, and particularly the restrictions on proprietary derivatives And I think that's an important part of what makes that movement viable. But I think it's also something that distinguishes it from the other parts of the public domain. And so I agree with you on that. I think that it's fine for you to consider that that UCITA has nothing to say on open source licenses. I'm less convinced than you seem to be that if UCITA was actually enacted, that a judge dealing with some dispute in respect of an open source license would say that UCITA had no application. I think that once UCITA is adopted in the places that it is adopted, that the courts will look at it and say, look, it looks like computer information to me, and here's a default rule from UCITA, and we're going to import it, and all the sort of fine distinctions between a license and a contract that you might try to draw, I think, are at least questionable. So let me just sort of say that in response. And in respect of the sort of the DMCA, part of the reason why I'm not drawing my arrows so much in terms of the sort of the constriction of information is because at least I want to sort of see what happens with the Felton case, and I want to see what happens with some of the other cases before I start, shall I say, over dramatizing the effect of the DMCA rules. As you know, I'm a very strong critic of them. I've written amicus briefs basically saying there are free speech interests here that are at stake, but at the moment I'm trying to sort of keep myself in check. So there's that. In the back.
The map that you've drawn is essentially a legal map, and I think the disagreement there was about, a legal issue. Is this particular copyright license, not a contract, but a copyright license, does that make something part of the public domain or not? Perhaps there's a need for another map as well, which is a functional map, in which those two domains will essentially be the same, and perhaps it'll add some extra insight into the impact of particular laws on, the functional ability of people to do particular things with particular information.
Yeah, I think that's very important, and I actually think that Yochai Benkler's work in particular has been useful in thinking about not a sort of a legal map, as you point out. I mean, I'm a lawyer, so I make a legal map. What can I say? But I think that it is actually in the direction. I mean, I think one of the reasons that I came here, and one of the reasons that I think many other people came here, is because we want to actually move beyond the sort of the legal discourse that we've been engaged in, and try to sort of draw upon a larger kind of body of thinking on these issues. And so, I welcome your suggestions, and I think it is that my efforts, small as they may be, are efforts to sort of build in that direction. So thank you for the comment.
If you had in the paper the comments about the SSCA, sorry, make sure I had the right.
I think it's called Secure Systems and Standards Certification Act.
And it's seemingly apparent ability to outlaw software that doesn't follow suit within that act. What more comments would you have to give on that other than the things you said in the paper?
Well, it's hard to comment on something which actually isn't a law and isn't even a bill. And so I tried to just flag that legislation as something to pay attention to and see how it evolves. But I think before we start getting all roused up about it, it may turn out to be something that we should be extremely roused about. But at the moment, it's just, I think, in a kind of concept stage. So I think I'm just going to say I tried to flag it here, but I'm not going to try to go more. I do think that there is a kind of logic to these secure systems, and that sort of if efforts to try to promote voluntary standards to get secure systems don't work, partly because some of the players in the marketplace have divergent interests from the owners of the content who want strong locks. then it seems to me that the logic is to go and get a mandate that all the systems have it, so that you don't have to worry about competition anymore. Okay, one more. Barbara?
A comment and a question. When you talk about, can you hear me? We talk about the database bill impacting science. I think that that's certainly been recognized a lot by the scientific community, because my understanding is that the treaty, was it 96, was that the treaty was halted in this country, the support of it, because of a letter written by the presidents of the National Academy of Science, National Academy of Engineering, and National Institutes of Health, probably led by Bill Wolf, who was the head of the National Academy of Engineering. My comment was to sort of try to add a slightly orthogonal dimension, and maybe this is inappropriate here, to the discussion of the DMCA and the Commons, which is that there's also the whole technical component of this. And one of the problems with the DMCA and the SSSCA, if it gets enacted, is the impact they have on computer security, because they're basically prohibiting a lot of computer security R&D as written.
I couldn't agree more. I think those are really important things to mention. I do think that actually the person who was just making the comment is Barbara Simons, who was the president of the Association for Computing Machinery, which, for those of you who don't know, is a international society of computing professionals. I think it's either 75 or 85,000 members worldwide, and that computing community and the scientific communities have actually been very engaged in the debates about expansions of intellectual property rights, and I think have made tremendously important contributions to the understanding about some negative impacts that overbroad laws have. And I think to the extent that some of these laws, like the database law, have been not enacted in the United States, it's partly because of that, and to the extent that the DMCA has at least something of an encryption and computer security research exception, it really is because of the acts of the sort of the computing people to bring that to our attention, and they were more successful, frankly, than the law professors in trying to articulate reasons for those carve-outs. So I think that's important to understand.
Well, thank you, Jamie. It's really wonderful to welcome you all here. As you can see and imagine, the three of us are having a good time, so we thought we'd let the rest of you in on it. And we are having a good time having you with us, and we hope we'll continue this dialogue. We're certainly very happy to be at this very great research university. The topic of the paper that you have before you, it is before you, but it's at the back of the book instead of the front of the book. Paul and I were late. We were supposed to do 2 papers, and instead we did 1. And that was part of one of our biggest epiphanies. It was to realize that only 1 was needed, but that it had to integrate the law and science more deeply than we had done in the past. The title is Promoting Public Good Uses of Scientific Data, a Contractually Reconstructed Commons for Science and Innovation. I'm going to walk you through the paper overall, focus on the overall legal and conceptual framework, and then tomorrow in the science sessions, Paul is going to explain the e-commons solution that we propose in more detail and in light of the scientific institutions that we hope to be able to coordinate. Now, the first part of our paper is called Deconstructing the Public Domain in Scientific Data, and we also have engaged in a mapping exercise using the categories that Jessica pioneered, Pam has developed here. We've turned those categories, tried to fill those categories of public domain matter with the scientific universe. You may think that's easy to do. It is really, I think, it has been almost impossible, and we are amazed that we've actually done it. The universe of scientific data exchange is vast, it's complex, it's beautiful, especially in the United States, and it's virtually hidden. It operates out of sight, and even, I would say, the bulk of the members of the scientific community themselves have only a very approximate notion of it, that part of it that touches them and not the rest. This reality came home to me some 5 years ago when Paul and I were indeed fighting the database wars on behalf of the academies. and he took me out to a meeting of the World Data Center executives, and listened to them talk about the problems that would be created in these universal data archives, in which suddenly we start getting deposits from abroad, conditional deposits, when the whole genius of these archives is to unify the data from all the sources and make them available to everyone in the world without restrictions. We asked some of our colleagues in science to please prepare a map for us so we could use it in our advocacy efforts. We never got one, and so in the end, we had to do it ourselves. And I hope you will look at that very carefully, because Paul will expose you to some of the features that you'll see, but it is indeed very counterintuitive. Secondly, we talk about the economic role and value of the public domain in scientific data. I think a lot of that ground was covered this morning, and Paul will cover some new insights that I think some recent work by Stiglitz has contributed about the efficiencies of when is it efficient for government to do it rather than the private sector. What I emphasize today is that the United States system of innovation, our national system of innovation that emerged in the post-war and Cold War environment, was not something that some Solon created and that we can sit down and argue about. It has arisen serendipitously, but with a marvelous construction, and it has been premised on enormous flows of cheap and openly available raw data, largely generated by the United States government directly or indirectly by government funded, almost the vast bulk of which is made available to everyone at the marginal cost of delivery. These upstream flows of data were largely subject to the sharing norms of science, and in my view, they are one of the principal reasons that explains why our national system of innovation so distinctly and by so much prevails over any other in the rest of the world. Our mammoth basic science enterprise has been fed by unlimited quantities of raw data that anyone could own in their upstream embodiments, and no one could that anyone could take and no one could own, including, least of all, their major supplier, the government. Once basic science converted these upstream data flows into theories, discoveries, and applications, then larger aggregates of information, bundled as applications, could indeed be owned, as we know, patentable inventions and copyrightable works of authorship, but which are, however, rather palpable and large in size. In this regard, I call your attention to Elinor Ostrom's great book, her first major work on governing the commons, the evolution of institutions for collective action in 1991. In that book, she describes certain ancient dynasties that flourished only so long as they were totally organized, often in totally anti-democratic ways, but they were totally organized to maintain some essential common resource, for example, complicated irrigation systems. And then when these kingdoms or dynasties were no longer able to maintain that resource, they disappeared. I have this troubling vision of some future archaeologist in the year 4000 tracing the decline and fall of the United States, whose wealth rested on constant innovation, to the date on which Congress finally enacts an exclusive property right in non-copyrightable collections of data, like that already enacted in the United States, and this date is approaching very fast and is likely to be this year. So our second topic is, well, if this is the situation and we have benefited so much from it, what are the pressures on the traditional functions of the public domain in science? Part of the pressures are internal, the growing commodification of data within the government and within the scientific community itself, and Paul will talk more about that tomorrow. I'm going to spend a few words on the legal onslaught. You've heard about it already in Pam. I'm going to draw some more conclusions from the legal onslaught and concentrate on the major legal initiatives. I talk about others in the paper, but the main one, of course, is this sui generis intellectual property right in data that restricts the availability of data as such for the first time in history. Now, because of time limits, I really do not have time to walk you through the European Database Directive, the sui generis regime. Many of you are not intellectual property lawyers. You should start from the proposition that it is like nothing we have ever seen before. It protects any collection of data, information, or other materials. The basis, the criteria for protection is a substantial investment. That is, it is a super strong exclusive property right in the protection of investment itself for the first time in history. It does not require any contribution to our knowledge. It gets very strong exclusive property rights to extract or utilize all or a substantial part of the contents of the protected database. The exclusive right of extraction pertains to any transfer in any form of a substantial part. The exclusive right of utilization is slightly limited in the sense that it must be a public distribution. Private use is not covered. It covers it gives to the first comer the total control over follow-on applications, and it gives that control perpetually. Any new investment in a follow-on application renews the term of protection not just for the quantum added in the follow-on application, it renews the right in the entire database and so on with each new investment. Moreover, governments in Europe are not subject to the kind of laws that we have. They do own these rights, and they do intend to exercise them as a kind of tax on everybody who uses them. There is an exemption of so-called for insubstantial uses, but you draw that line at your peril. And they are not giving national treatment, and on the other indeed, and they have begun to invade our space, attacking libraries and other institutions, saying, why are you putting this online when we protect this over here? The EU's directive on the legal protection of databases breaks radically with the historical limits of intellectual property rights in at least three ways. First of all, it gives an exclusive property right in the fruits of investment. Now, before, in all our history, we do have some protection of investment, but the protection of investment is always based on liability rules. Here we have an exclusive property right, and we do not ask for any predetermined level of creative contribution. Secondly, it inserts this strong property right on aggregates of information which had heretofore been considered the unprotectable raw material or basic input available to all creators working on all other intellectual property rights. And it confers this right in perpetuity with no obligation to end up in the public domain, which had heretofore, as you heard this morning from Mark Rose, had become, in the Enlightenment age, the justification for this right. It will become it will be given to subject ownership. I will pass over the database controversy in the United States to draw some implications from this. In the United States, the two coalitions are fighting. The one bill would give more or less the same results as H.R. 354, would give more or less the same results as that in Europe without perhaps the perpetuity kick. We think we've nipped that one, but just about everything else. The H.R. 1858 would be a kind of liability rule, but it has a surprisingly strong protectionist incremental stuff has crept into it over time as an effort to tempt the other side, and it failed, and you can't get it out. For example, it will protect discrete segments of databases which are copied. That does give a derivative work right. Of course, there's some tests of their competitive effect, so that's the outcard, but it does also last forever. Instead, I'm going to talk about now the final part of part two, the impact of this shrinking domain, public domain, on science. And my first point is that we are introducing here a market-breaking approach as opposed to a market-making approach. What do I mean by that? First of all, we predict a huge and adverse impact of these trends on our national system of innovation. As we said, and as I have said in an earlier article, information has a dual function. It has an input function. It has an output function. We are suddenly, and as Pam has dramatized for you, we are suddenly attacking, putting a siege camp in the upstream part of this equation. What does that mean? Well, it means that we will have a radical change in the economic nature and role of intellectual property rights. This morning, you heard even those who questioned where we're going with intellectual property rights. No one, I took it, questioned at least the fundamental positive role that intellectual property rights presents, which is to make markets possible where previously there existed a risk of market failure owing to the public good nature of intellectual property rights that Jamie so brilliantly explored for us. In contrast, an exclusive property right in the contents of databases breaks all existing markets for downstream aggregates of information which were formed around inputs of information that were previously available in the public domain. Why? Because it conditions it conditions the continued existence of these markets for intellectual property, for intellectual goods on 3 new conditions. First, on the willingness of the information suppliers upstream to supply at all. They can't hold out. Feist v. Rural is about a holdout of something as trivial as a telephone book. Imagine when it gets more important. Biotech stuff. Secondly, the upstream supplier may not be willing to charge prices that the downstream aggregators, who mostly are, or the ones we're concerned about, are nonprofit scientific organizations, can't afford to pay. And nothing compels them to make it available at a lesser fee. And most important of all, the further availability of these inputs will depend on the willingness and ability of these upstream suppliers to pool their respective chunks of information in contractually constructed cooperative ventures. And if we can't do it in multimedia transactions in Hollywood, how are we going to do it when science needs to access and constantly access dozens and sometimes hundreds of databases at one point to address altogether a chunk from this and a chunk for that to address the hard problems that science addresses? This is the last most telling complication of all. It creates new and serious barriers to entry to all existing markets for intellectual goods owing to the multiplicity of new owners upstream, any one of whom can hold out and break the chain that we need to put the whole operation together. At the best case scenario, the cost of research and development activities seem likely to rise across the entire economy, wherever R&D is being done on the basis of data that has to be acquired. And this stranglehold is going to increase with the market power of the large database suppliers, because as Benkler has rightly shown, the economic reason of our initial conclusion on this aspect is that what will happen, it's always easier for the big mega database to add on than it is for new suppliers to come along, recreate the stuff, and compete with them. And so the hold of these mega suppliers, the 6 companies that are promoting this, and their offspring will get greater and greater. Well, what all this demonstrates, of course, as Pam and I said in '97, as the academies have said twice, is that an exclusive property right is the wrong kind of solution for the database problem. Data has previously been protected only on the basis of liability rules. To the extent that there is a possible risk of market failure, what we need is a liability rule to deal with the market failure without impoverishing the public domain. And I have developed such a regime. I proposed what I call it a compensatory liability regime, and it would solve absolutely the problem of follow-on innovation, as I have explained in of green tulips and legal kudzu, repackaging rights and subpatentable innovation, and you're welcome to have copies to that. There's not a chance in the world that either one of these camps would support that, because both sides want to push something over on the other side. The supporters of strong database protection laws and of UCITA make the claim that the benefits of private property rights are without limit and that stronger and more is always better. They expect a brave new world in which huge resources will be attracted into the production of databases in response to these powerful legal incentives. Instead, we predict a steep rise in the cost of information across the global information economy and a serious long-term anti-commons effect that will over time tend to suffocate innovation by making it contingent on these complex contractual chains. We predict less innovation, not more. And in place of the explosive production of new databases that the proponents envision, we envision a progressive balkanization or feudalization of the information economy in which fewer knowledge goods will be produced as more tithes have to be paid. What we see is not some brave new, amazing new information economy. We see an economic model all too familiar from the not too distant past, that of the Middle Ages, in which goods flowing down the Rhine River or goods moving from Milan to Genoa were subject to dozens, if not hundreds, of gatekeeping tithes. And that's what we're likely to get once again. Now, the challenge for science, my final topic, is very grave and very serious here. 6 years ago, Paul and I saw that all the lobbying and all the coalitions were not going to stop the commodification movement, and our being here today shows that we were right. Indeed, we saw and were also right, that and you're even righter now, as the paper by Ryan Eisenberg shows, that unless steps are taken, both the government and universities are increasingly going to join the trend. Our view is that to maintain the sharing ethos and preserve public access to scientific data, science is going to have to take charge of its own data resources and it's going to have to reconstruct some functional equivalence of the pre-existing commons in a way that takes commerce into account, but that does not allow commerce to dictate the research needs of the scientific community. Following Ostrom and Hess, we need not accept that the only choices are between exclusive private rights and public ownership. We can instead, and we should, organize to manage and share the scientific community's most precious common resource, upstream flows of data for basic research. Now, again, 6 years ago, the only models, we saw the need, but the only models that were on the table were what? Collection societies, which are at best slightly odious, and paying public domain, which is at best a kind of a tax. And then in a very fateful day here, we ability of data to the scientific community over time. If those rules are written by the university's development offices, they're going to be terrible. With attempt of each project to maximize the return to each group of scientists at that point, that's going to be the end of it. So carried to an extreme, the war of research entities against one another conducted by these legal officers is going to obstruct and finally destroy the scientific commons. And what we need to do is block that and get all of us thinking about doing something more positive with this resource. So we propose a kind of multilateral treaty, and I'm not joking. I work on multilateral treaties all the time under the TRIPS agreement, and these 25 leading research organizations and the NSF and the NIH, they are like potentates that have to come together and stipulate a treaty on intellectual property rights. We need to put them together, a treaty between the leading research universities, the science funders, and the scientific communities to rewrite the rules governing scientific data from the top down in order to recreate by consensus and agreement a dynamic public domain that could ensure a continuous flow of raw materials through the national innovation system, notwithstanding the pressures for commodification. We've got to create a public or quasi-public space, even though each institution separately engages in transfers of information to the private sector. The strategy requires a set of rules, a set of standard form licenses, organizational structures, all tending to maintain this dynamic commons in which legal rights are used to strengthen the sharing norms of science along a horizontal public access dimension while permitting a vertical privatizing dimension which has not, however, the power to interfere with the horizontal dimension where everyone plays by the rules or doesn't get funded, ideally. That's my dream, right? Now, in part 3 of the paper, we have worked out a relatively detailed, very tentative, but quite a serious attempt, an analytical framework for 3 spheres of influence. Government-generated data, which we try to keep relatively pure, and the spheres of academia and the private sector, where we allow more conditions on access to deposited data for research purposes in a relatively impure environment. We envision many gradations from the unrestricted type of GPL that Morgan's pioneered. We envision lesser GPLs and very much lesser GPLs if need be. The point is to regulate firmly, but with suitable options along the horizontal nonprofit public access dimension while allowing considerable leeway in the vertical access. Let me point out that we do not shrink from addressing hard problems. Hard problem is posed in Eisenberg and Rye's paper. What are we going to do about databases that function as research tools for scientific research when the university says this is our bread and butter? Okay, at the very, very extreme, we are willing to allow even money to change hands. We are willing to allow the universities to charge each other, but our outer limit is compensatory liability. Yes, you may have to pay something for it. You cannot exclude, and what's more, we have there's a built-in reach-through. We can reach through and borrow back what you have done in your applications of it, paying you a compensatory liability at the outer edge. The right to payment would foreclose any right to exclude and would carry with it the right to borrow back. Tomorrow, Paul will walk you through our concepts of both the pure and the impure scientific commons as we envision it, and how it would affect different communities. The basic idea is to make a virtue out of a necessity and to link up all the communities in a virtual universal archive, technologically linked with all kinds of modern file sharing devices. Harlan Onsrud has done some pioneering work in that. He's going to talk to you about that tomorrow. We welcome your inputs and your support for this important project, and we really do believe that its success or failure would have a lot to say about where our national system of innovation goes in the next 20 or 30 years. Thank you for your attention.
Okay, we'll open the floor for questions.
Jerry, you've raised something that I think has been missing from some of the other discussions, which is the international dimension to all of this. We're not talking about intellectual property rights in a national vacuum. We're talking about them in a very large international context. And as we speak, the WTO ministerial is going on.
Absolutely, in Doha right now.
And there are three streams there. There's TRIPS, there's the e-commerce discussions, and then there's this new conversation they want to have about technology transfer. How do we feed into what's happening there? Because as we saw with the Uruguay round, the deal comes back, you have to change your patent system, or the whole deal unravels.
That's
and
right.
no one was going to stand up and fight the patent system battle if it had the chance of unraveling the whole
right.
trade agreement. How do we
Okay,
influence that?
actually,
whole
I
process?
have just given a paper on this for the International Association for International Economic Law that met in Rennes, and I show what the progression will be. There are only two possibilities. Either the United States and EU will ally around the strongest possible regime, and then they'll try to pose that on everyone else, and then anything else will depend on the ability of the developing countries to coalesce and oppose it. Don't count on that. And the other possibility is that if the United States adopts a lower regime, but again, be careful, lesser is not the lesser that Pam and I proposed, but it's already getting stronger by the hour. And if there's going to be a compromise, we've heard the chairman of the committee say that if the negotiators don't negotiate to a compromise, we will sit down and draft it ourselves. You can imagine what that will be like. And then, if we go to a lesser regime, then there'll have to be some kind of accommodation. Now, thinking about accommodation, there are limits to that. First of all, there are already some 50 countries that have to buy into the European regime. Why? Because if you want to join them or you want to be affiliated with them, you have to sign on the dotted line. Nothing will change them. Secondly, they're going around the world, while we debate, they're going around the world saying, well, we could offer you this wonderful trade agreement. Latin America is the case, but we want our database law to go with it. And thirdly, so they're fooling around with that in Latin America. And thirdly, governments are suddenly being under the table. The whispering is going on. Gee, you can solve a lot of economic problems by making everybody pay for this data. So now Mexico has already adopted a regime like theirs. Korea has now introduced a bill to adopt the European view. Now, if there are two types of laws on the table, one softer, one stronger, then it is possible to have an umbrella treaty along the lines of the Geneva Phonograms Convention, and that has very interesting ramifications. You can do a lot with that. All you have to do is have a general agreement to do what we said you should do, repress wholesale duplication, and then you can have a menu of options. You can do it by this regime, by that regime, or that regime, so they don't have to give theirs up, but we don't have to obey theirs. And the Geneva Phonograms regime has quite a good track record with regard to public interest exceptions and other good things. So I believe there is a way of solving the international tension and eliminating this reciprocity barrier, even if we subscribe to a lower regime. My fear is that we won't, and then the only hope is the developing countries, and there are a lot of fears there. For example, thinking about those negotiations, while they're telling them about, suddenly WIPO has begun to shed all sorts of tears about traditional know-how and folklore, right? Okay, the Romans saying, beware of Greeks bearing gifts. What they're going to tell you is, we could give you these wonderful things if you just sign this database regime, in which case they mortgage their future. What do developing countries need more than access to scientific and technical information at the cheapest possible cost? And the dollar value of that is not, the dollar value of culture and innovation together is like a drop in the bucket compared to that. So these are very serious problems.
It's a gloomy picture you paint, but I offer a couple of small beams. one of the things is that I think that universities are going to discover, as MIT did, I believe it was 2 years ago, that it's costing them more to defend their intellectual property than they're actually gaining from the licenses. In MIT's case, it was a differential of about $2 million, I think. You know, and nobody in a development office is going to go for that over the long term. The other thing is that the National Alliance for Scientific Computing, which I sit on the advisory board of, decided last year to make it a policy that there would be no proprietary work done on the grid here in the United States. And I just was at a meeting of the Global Grid Forum where similar policies were being discussed.
Well, and we must say that the State Department held a roundtable on this issue this summer that we were at. It was quite a good thing, and the Bush administration has not yet formed a policy decision. Nevertheless, the pressures are very great. Steve, we have here Steve Berry from the University of Chicago, one of our main speakers tomorrow on this topic, and he was chairman of the Bits of Power committee that produced the first Academy's work on this, and he's also the Home Secretary of the National Academy of Science.
Jerry, I have a question for you. Suppose that the United States were to adopt a very open policy. What do you imagine would happen if the United States simply went into with its open policy, went into competition with the EU and its adherents?
Well, if you remember,
Would there be a clear outcome? Do you think a clear winner?
if the United States government were totally dedicated to breaking this lock, then we are still the 10,000-pound gorilla when it comes to scientific data. So I remember one of our first sessions, I proposed the poison pill. I mean, if you really want to get nasty, we can take all their charges for scientific data, up them by 20%, put them on our data, charge it back to them, and their users will end up paying for everything. They'll soon get tired of that, and they'll cry uncle, so long as we're the 10,000-pound gorilla. But the fact of the matter is that it is much more complicated than that, because as you see, we know about the world data centers where suddenly there are gaps appearing in the databases because of these conditional deposits, which they from England say, which they can't accept. And now we heard this morning from very reliable sources about libraries being approached by lawyers saying, take this stuff off the database because it's protected abroad. Now, last time I looked, this was the United States and our laws applied here, but nevertheless, but via Moscow too. But nevertheless, there is a lot of concern, and I don't know the answer to that. Okay, but I think it's one of the things we'll be talking about tomorrow. We want to hear a lot from Maurer, who's here. Steve Maurer is with us today and has probably more up-to-date knowledge on these competitive aspects of the database industry than anybody that I know. Julie.
Jerry, I assume you know way more about this than I do, but I'm given to understand that in Congress, Chairman Coble has now linked the fate of database legislation with the fate of the TEACH Act. And if one has to be a pragmatist and think about how the educational community should trade off against one another, database protection and exceptions for digital distance education, could you comment on a framework that they should use to think about that?
That's terrible. The Italians call it the uccello di malaugurio, the little bird of evil tidings, right? And you're the second one to fly in on this very theme this morning. Lolly Gassaway, who's with us and has worked on these database issues and will be on the panel tomorrow, was telling me the same thing. And that's very dreadful. It's very artful because he knows, Sensenbrenner knows perfectly well that the universities are already divided on the database issue because they have their own protectionist interests and that they care very deeply about the teaching bill. But as Lolly was saying this morning, there are two different sets of communities and the values are enormously different. The gains from the Teaching Act are a real immediate mass gains to education everywhere, and the fallout from the database bill is so negative that it is amazing. But you know, when the lie gets big enough, it's amazing how many people don't want to see or understand it, right? I mean, this got through the European Parliament without a beep, right? There was no public outcry. Here, at least, there's been transparency. It won't get through in the dark, but I fear that by maneuvers like this, it may get through all the same.
Well, I guess my question is, what would you say to them to make that clear?
Lolly
Make that
has the
trade-off.
best answer. Where's Lolly? Tell them what they should say. And she is a big promoter of the distance learning and is a major architect of that.
Well, it seems to me that one of the real problems is, as you stated it, it's not the same parties. The database vendors are not the major players in distance learning. It was traditional publishers and creators of multimedia works aimed at the classroom. And so the next thing we could say to them is, you're just not dealing with the same parties. And we crafted this negotiated agreement on the Teach Act. It's not perfect, but we even had the publishers agree. And we're going to lose that if it doesn't pass the Senate.
How much he cares, I don't know. That's the question. This is very hardball politics, and also, some other people are against it. Now, in the Senate, you have to know that there are very staunch people in the Senate who are skeptical of it, and Townsend's committee is skeptical of it and is really working mightily to try to do something proper. But the interests against this are very powerful. We need to wrap it up.
No, we have actually, because we have a little bit of extra time.
Okay? Yes, sir.
So you say you talked about sort of like your, as you called it, the top-down approach to the problems and the treaty making. Can you say something about what the complementary bottoms-up approach?
Well, the bottoms up would be if every university technology office continues to write the rules that we bargain to impasse, as Rebecca has shown before, and as Artie Rise and Rebecca's paper today suggests is reaching the point of no return. So what we would try to do is bring these, first of all, develop some sensible rules, and then bring the funders and the universities, the top ones, together and see if we can't hammer out some basic principles and then some basic licensing agreements, or call them whatever you will, to implement them, in which the sharing ethos would be preserved by contract, and there would be do's and don'ts. One of the helpful things this could do, for example, is arm the funders to make better contracts. The agencies, not just the funders, about NIH and NSF, but the actual agencies that now commission and do a lot of outsourcing. They have the right to put contractual conditions into their contracts, preserving the public domain. And the expert on that topic is sitting down here in front and will be chairman of this panel tomorrow. And he could tell you how hard it is sometimes to make them do that, at least to put in the terms that they ought to put in. By law, the cost of delivery, the making available of government-generated data at the marginal cost of delivery is a OMB directive and their statutory enactments, etc. The contracts written by the agencies, whether they're funding agencies who fund research or national agencies that are outsourcing it, are not controlled directly by statute. They have often a great deal more freedom, sometimes more, sometimes less. We would hope that our approach would give them some guidelines and some incentives for ensuring that public access is maintained without in any way impeding privatization, value-adding uses in the private sector, making money off it. We want to encourage all that. And something else that we want to encourage, and that Paul will go into tomorrow, we know of some very prominent private sector firms that are as concerned about this topic as we are. They know that the success that they have had has depended on their ability to upstream data. They're desperately afraid of the same things that we are afraid of, and what we would like to have, sort of things that Mulligan's, we'd like to be able to have some licenses affecting them that would encourage them and enable them to make their data available for public access without being afraid that they're going to be ripped off.
Oh, yeah, because I didn't have a microphone. First, I'd just like to note that in the panel, you'll see a number of places throughout the conference where we'll actually be discussing attempts to grow the public domain, not by criticizing or litigating or bringing constitutional challenges to intellectual property legislation, but rather by creating common property regimes that can be set up either privately or with the aid of public institutions or through networks of individuals. And so you'll notice which I thought was extraordinarily useful in your various jamming and seed camps and so forth models that you put out. The thing that I was interested by was the fact that you said, there are indirect effects of spillover. But it struck me that one of the major effects of what you were doing, and actually one of the major of what you were describing, of the DMCA in particular, was the need to kind of remake the internet so that it fit the business model imagined in these plans. And as I and Julie and others have argued, the logic of the economic logic of these systems is a logic of perfect price discrimination, where you sell to every user exactly the marginal cost, which means you need lots of data and you need identifiable users, and anonymity is bad. The logic of what Jerry's saying is the internet shouldn't be so abolishing of geography, because you need to be able to monitor cross-border data flows. So I guess I'd like you to talk a little bit, not so much about the mapping of the public domain, but the implications, if you were to have drawn your map, not about the biggest threats to the public domain, but the biggest threats to the kind of architecture of the internet. Would the DMCA be more important, and UCEDA less important? And I'd also like to hear from Jerry at the end of that about what he thinks in terms of the data flow.
I think that's important, because part of what I grappled with when I was trying to write the paper is what's a threat today, and what's a threat over a longer period of time. And UCEDA is a very immediate thing, because a couple of states have adopted it, and because there's been actually a lot of money behind trying to promote it. And even though it hasn't succeeded, I think it's too early to say, oh, we won that war and da 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 da. Okay. And with the database legislation, we've had a series of bills, and that feels pretty immediate. The DMCA, because it's still relatively new and there are some kind of open questions, we don't know exactly what's going to happen with that. I think that there are going to be some places where free speech interests are going to be important, and I think courts can find things in that legislation to tweak it so that it isn't quite as bad as it might otherwise be. But the question about what's really a harmful impact over time, I think, is a really important one. And again, we're sort of in a speculative situation. Sort of my sort of nightmare scenario is the nightmare scenario that basically says, yeah, the internet's totally re-architected to control, and you have something like the SSSCA, and no information actually can be played or rendered by any piece of equipment any place in the world without the tithe. Now, that happens to be my own personal nightmare, and I see some things and I see some economic logic that suggests that something could move in that direction. But I'm trying actually not to be hysterical about it. I'm trying very hard to say that actually I think there are also economic reasons why interoperability and open systems are very valuable, and I'm less convinced than my fears might suggest that architecture of perfect control is something that will be acceptable. One of the things that I try to talk about in the paper are sort of ways in which one might try to sort of restructure the politics of this conversation so that and draw upon people from other sectors so that you have a politics of intellectual property and a politics about the commons and about the internet that actually does preserve the things about it that are really valuable, which I think Jessica also talked very nicely about this morning. So I'm not really a deeply optimistic person, but I'm sort of optimistic.
Jamie, that's a very searching question, and let me give you a square answer. First, let's look at the DMCA. It is indeed, as Pam says, a moving target, and it keeps having these oddly unpredictable things. For example, because we don't have a database law, the courts are cramming copyright law into non-copyright, so that is databases that lack any creativity, into stuffing it into copyright law now. The opponents of the database say that's wonderful, and I say, what do you mean? Now you're protecting algorithms for at least 150 years, so you've got another nightmare. But the real nightmare is not just UCEDA in itself, but what it stands for, and it's going to have to be addressed. UCITA, what's really odious about UCITA is that it uses the language of the great Professor Llewellyn's Article 2 to pervert his deepest purpose. The whole exercise of Article 2, the whole point, was a Coasian analysis, a Coasian approach to buyers and sellers in zero transaction cost. What is the ideal transaction that they would have bargained for? And instead, what is the purpose of it is to vindicate mutual assent. And the whole point, whole thrust of Article 2 is to use that language in order to vindicate the strong seller's right to impose whatever terms they want. Don't criticize the software. If you have a dispute, don't even think about it. We'll disconnect you, and so on and so on. So, as you know, with Jonathan Franklin, we proposed. First of all, but this problem is not going to go away. Even if UCITA isn't adopted, the problem of the adhesion contract is the problem of the 21st century, in my view. And we're going to need some new doctrines. Franklin and Reichman propose a public interest unconscionability doctrine that give courts some power to consider the impact on other systems like the federal system of legislation. We think that's going to be essential. And more than that, we're going to need a new doctrine, and we're going to have to look at abuse of contracts. We know about abuse or misuse of intellectual property rights, but when you take an intellectual good, you surround it with an electronic fence, you force everyone one by one through an electronic gate subject to a click-on license. This is a privately created, privately legislated intellectual property right. It is erga omnes, no matter what Easterbrook says about it. And if there are no limits on what you can do, then we have serious trouble. Now, a very interesting concept of limits on what you can do is in H.R. 1858, the soft database bill. It's not a very good bill in anything else, but its proposals for standards of misuse are the best I've ever seen. And I believe that could create a basis for standards of misuse of contracts and intellectual property licenses that we really need to contemplate. That's the best I can do at the moment. We have behind you,
Paul.
Paul.
Especially with regard to national security, there's huge carve-out from the federal data that are produced based on national security protections, which take many decades. As you may know, there's information that's classified from World War I still in the National Archives, and there's tremendous amounts of data that are collected by either federal labs or by contractors or by university researchers for the Department of Defense and other and Department of Energy, which are it's up there.
You have yokai behind you. You have time?
Agree. When I started drawing the map, I said, I need a place for that.
Yokai.
Something more narrowly specific to your fascinating proposal on the treaty, which is the starting out with the assumption that you're going to get a liability rule or some form of compensation flows. I mean, you've done a lot of work on liability rules, but largely in the context of entities that rely on revenue flows from specific innovation.
That's right.
It seems to me that there's one fascinating aspect of this paper is to bring beyond the general claim and to actually have a lot of detail on why it is that revenue flows tied to specific bits of data are not necessary for this enterprise. If you're organizing a large-scale treaty level with the backing of the national academies, it's not clear to me why you're opening position vis-a-vis the administrators who may think of themselves as setting up commercial entities, that the position is no compensation flows. And when they say, but how do we live? You use your math to say, well, we live very well without compensation flows that flow to bits. The reason is that there are aspects of this compensation flow that replicate, even though we don't have a slew.
No, we know.
So
We know.
smaller
We hate it.
research.
Yeah. As much as I love liability rules, we hate it. We put it as an extreme outer edge, and the doubts that I had about it when I put in there were vanished when I read Artie's paper. I mean, the reality of this research tool argument. We would hope to try to encourage them to go to options 1 or 2 without doing that. But I can see with some biotech databases, for example, and we have to get Maurer's inputs on this tomorrow, but I can see that we're going to hear, what do you mean? We're going to hear the same argument that we hear from Reed Elsevier. What do you mean? You are our target of opportunity. and I must say, having been in the trenches for 6 years, the universities like the American Medical Association it's an uneasy ally, right? It speaks with 2 voices. It has its research interest, but it has its stuff to protect, and you never know which voice is coming at which time, and we have to deal with that. But we are totally in agreement with your sentiments, and if we could, we'd keep it out. It is our it is our dirtiest license, and we're prepared to try to hide it somewhere where you can't find it without a lot of difficulty.
Okay, thanks to the panelists. So.